It's with great pleasure that I introduce Sergio Muñoz Sarmiento. Sergio is an artist, lawyer, writer, and teacher who's interested in the relationship between contemporary art and law. His interest in law and language led him to attend Cornell Law School as an art project. Think about that. He has exhibited domestically and internationally in venues including Gemini, G-E-L, or Gel? I'm not sure. Gemini Gel in Los Angeles, Apex Art here in New York, New Life Shop in Berlin, and the Museum of Mexico City. In 2010, he founded the VLA Art and Law Residency Program, the first residency of its kind, as well as the Art Law School, which is a lecture series on practical legal issues for artists. His legal experience includes advising artists, galleries, foundations, public charities, and nonprofit arts organizations on issues involving intellectual property, moral rights, and free speech, and artist-gallery disputes. We should probably talk later. He was also involved in the Artists' Rights Act of 1990 on behalf of Swiss installation artist Christoph Buchel in his case against Mass MoCA in North Adams, Massachusetts. He's taught and lectured at universities and art schools, including Harvard, Cal Arts, NYU, Parsons, and here at SVA, where he currently teaches, and he also currently teaches contemporary art and law at Fordham. He's teaching, as many of you know, a workshop on art and law here at SVA this current session and also this coming spring, and I'm hearing really great things about it. Sergio received a BA from UT El Paso, University of Texas, an MFA from Cal Arts, a Juris Doctor, a JD from Cornell, and was a Van Lier Fellow at the Whitney Museum of American Art's Independent Study Program in Studio Art, the famed Whitney ISP. Please join me in welcoming Sergio Muñoz Sarmiento.
Thank you. I want to tell you a very quick story that it just hit me. I didn't know Mark was going to be here, but when I applied to, or decided to apply to law school, I had a very good friend of mine from the ISP named Carrie Tribe. And she was very happy to hear that I was applying to law school. And she says to me very humbly, you know, Sergio, my father is a lawyer. And if you want some advice, he would probably love to give you some advice on going to law school. So I said, sure. Gives me his email, and I email him very nicely. He responds about 4 in the morning to what were the pros and cons of law school and what were the best law schools to apply to. And we had a quick conversation, maybe 3 or 4 emails. I go on to law school at Cornell, and I'm taking one of the seminal foundation courses called Constitutional Law, or Con Law. And I keep seeing every other footnote referencing a Lawrence tribe. And I'm thinking, geez, this guy is quite seminal in the history and in the interpretation of the US Constitution. So I asked my professor, and she's like, yes, he teaches at Harvard Law School. He started teaching there in his 20s. He's like a genius. I said, tribe. And I emailed Carrie Tribe, and I said, isn't by any means or any way related to you? He says, yes, that's my dad. I just didn't want to tell you that. And so I felt really both embarrassed and privileged, because here I thought I was just emailing any lawyer. And little did I know, he pretty much wrote the Constitution. So anyhow, thanks for coming out. I am going to present a 4th version of this talk that I've done at a few other places, Brown, Yale, and Irvine. But I want to begin by talking a little bit about the work of Mary Kelly, which some of you are familiar with, and if you're not, you should be. But in particular, I want to talk about her canonical postpartum document project, which took place from 1973 to 1979, and its relationship to the law of contracts. These are some very rough thoughts that I've had the last week or so, but I want to share them with you because I've been thinking a lot about contracts and their function and importance in the making and dissemination of art. Mary's work has been on my mind because it addresses, on a speculative level, the philosophical foundations of the law of contracts. In other words, what are the makings of a contractual relationship? Can we have imposed obligations without a signed document? What role does trust play in the making of contracts? And what are the differences between the act of giving, the gift, the act of promising, and the contract? Contracts are usually defined as a private law between two parties. They are seen as a principle of fidelity to one's word, regulated solely by the goals and standards of a community. Mary Kelly's 6-year memorialization of the mother-child relationship forms what lawyers call the terms to an agreement. Through the use of an inscribed slate such as this one, drawings on baby garments, soiled diapers, and used cloth fragments, we become witnesses to the negotiations, power plays, documentation, and creation of an obligation. In effect, the question posed is whether the mother and child have entered into a mutual contractual agreement. Has the child accepted the mother's offer? If so, what were the acts that make this relationship a binding agreement? And more so, are moral obligations, codependencies, any different or any less powerful than a legal agreement? To me, Mary's work is a moment in law, a moment of law, and a moment in the formation of law, and a glimpse to the unacknowledged traces of the materialization and memorialization of a promise between two human beings. Mary's document manifests the initial desires and reluctances of two parties in their intention to form an interrelationship. What is a contract but a tabula rasa, a blank slate upon which understanding between two individuals memorializes itself? And what is a contract if not an understanding, a moral understanding that both parties can rely on each other because both partners have agreed, via their signatures or actions, to be obligated to each other in duties, responsibilities, and rights? And if these duties and responsibilities are not fulfilled, what rights does each party have in case of a breach of a contract or a promise? Mary's document makes visible the power of inscription and the need to memorialize. The document is also a memorialization of the intent by one party to form an understanding, perhaps a lifelong agreement between a mother and a child. In effect, Mary's project asks, what separates a promise from a legal promise? And why have we, in the so-called art world, increasingly moved away from promises based on trust to duties based on law? Moving on, I would like to talk tonight of two main moments. One, my previous career as a gallery preparator, and two, my law school education as a performance art project. In the late 1990s, I was a gallery preparator for a New York City gallery where I was responsible not only for the installation, deinstallation, creating and shipment of artworks, but also for the conceptualization, fabrication, and construction of the structural elements that upheld the display of such artworks, as seen in this slide, the construction of temporary walls, and the installation of paintings. During this time, one particular phenomenon stood out. I began to notice that at each exhibition, at each opening, there would always be at least one person who would comment on the structural changes to the gallery before they would even comment on the art being exhibited. At this point, I began to wonder what role the so-called preliminary and underlying work had to the art being exhibited. The second moment I want to highlight is my decision to apply to law school and attend law school as an art project. This, the Cornell Law School project, consists of the entire process necessary to attend law school and become a practicing attorney. From my preparation for the law school admissions test, otherwise known as the LSAT, my application to 12 law schools across the US, the 3 years of law school, and my preparation for an admission to the New York State Bar. This project has been documented via text, video, and photography. Given what I have just detailed, I would like you to consider the relationship between these two moments, my life as an artist / manual laborer, and my life during law school, all while keeping this question in mind. What can the analysis of labor and law tell us about tangible and intangible property? In effect, what can it tell us about culture? So where does this interest of mine in the relationship between art and law begin? I will start with this action that I have never codified as being an artistic gesture. In 2000, while driving outside of El Paso city limits, I noticed something that I, as a former El Paso resident, had taken for granted: the vast West Texas desert landscape. I decided to look for, and I found, what appeared to be an empty plot of land east of El Paso. This site was difficult to access, and in fact, not known to the general population. My intent was to find a site that was not mapped out and to install a structure that would elicit an aesthetic experience, but only to those that happened to stumble upon it. With the help of a friend in a large flatbed truck, I proceeded to assemble playground equipment, a swing set, a slide, and a half-moon aluminum structure, and install them on this site without the knowledge or consent of anyone who might have had a claim to this land. I wanted to make a gesture that would most likely have a small audience and little to no impact outside of its own presence. It was a type of gift, I suppose. In 2001, exactly 1 year later, I returned to this site and found a community had formed around this playground. They had taken it upon themselves to build a fence around the playground out of wooden posts, cable wire, and discarded rubber tires. And you can see the rubber tires. This is a really bad image because it comes from a slide, but you see the rubber tires, the wooden posts, there's the playground equipment, and then they created like a entry gate to the playground. My interest in creating unmarked or non-indexed aesthetic gestures continued. My next gesture consisted of using building materials obtained from the same construction site in order to install 6 sheets of compressed wood overlaid with 6 sheets of gypsum board on the right side of the wooden structure of this suburban home. The intent, again, was to create a functional gesture that few would notice, and to which even fewer would assign any aesthetic value. The gesture would, however, remain in its physical state, but only in a spectral manner. For once covered over, it would be there, but not there. Again, this was not an artistic gesture. Although these gestures reminded me of my childhood days, when we would trespass onto construction sites and use building materials from the site to create our own playgrounds and make-believe worlds, it also reminded me of the work of a former teacher of mine. In 1979, Michael Asher was commissioned to install a project at the Museum of Contemporary Art in Chicago. Asher decided to remove 18 aluminum facade panels from the museum's facade and install them inside the museum as art objects surrounding a solid wood drawing. The connection between sculpture and architecture, between the function and ornamentation, was apparent. Asher's project would always be on view, either on the exterior as architectural decor or as art objects within the museum walls. Asher also asked that the panels be exhibited every so often for a 2-month period, but at the museum staff's discretion. Of notable interest to us is the fact that the museum, in an attempt to increase its permanent collection, had contractually agreed 5 months prior to Asher's installation to purchase whatever Asher produced. Although in effect the museum purchased itself, it did not realize that unlike much of the work hidden in storage, Asher's work would always remain in open storage. Asher's work is seen as art. Having learned from my previous 2 installations, from the there but not there, I decided to install an architectural sculptural structure on a suburban construction site, again without permission from the owner or the contractor. The 4 columns and arch that you see in the middle of the image were constructed and installed by myself, and again with the help of a friend. My intent, once again, was to create a structure that blended in and thus did not seem out of place, to make it so that the structure belonged. Now, what's interesting about these kinds of labor projects in El Paso is that there's a large migrant labor population that comes from Mexico and Latin America. And so 1 week you can have one group of laborers come in and set the foundation. The next week another group will come in and do the stud work. Then third week another group will come in and do all the sheetrocking. So what I realized was that the next group that came in would not necessarily know that that structure didn't belong there. And I don't have the image, I don't show the image, I show very few of them now, but there is a moment where, when I did go back years later, and on a separate project, a different structure on top of one of the homes had actually been sheetrocked and painted over and bricked. So I always thought that was kind of interesting, the kind of life that it that remained. These past projects dealt with tangible property. I will skip over similar projects and move on to a project that deals with intangible property, or more precisely, aesthetic property. This project, A Question of Property number 4, took place in East LA in 2002 and 2003. But unlike the previous two gestures, this consisted of me no longer installing any physical elements on a construction site. Instead, in a Duchampian manner, I opted to simply index this particular wooden armature that you see as a sculptural artwork created by me. This is an exhibition announcement that was created for this project, and these were sent out, indicating the location of my sculptural work, the dates of the exhibition, which were based on the moment of time that the new and the raw wooden armature would be visible to the general public, and the hours of exhibition, 24 hours a day. And the dates of exhibition, when I spoke with the head of the contracting foreman, I asked him how long the wooden armature would actually be visible. And based on the time, and he said when we start sheetrocking it, was when the exhibition would conclude. However, I did note that unless there was an added element to this project ran the risk of coming off as too simplistic and juvenile. So I decided to draft, with my pre-law school ignorance of law, a certificate of authenticity guaranteeing the originality of this project and naming the wooden armature as my project. The certificate also gave the owner of the project, for life, the sole aesthetic property right in the wooden armature, to include but not limited to aesthetic appreciation, aesthetic experience, spectral presence of the armature, and visitation rights. The certificate also stipulated that should anyone ever want to exhibit this project, neither the photo documentation nor the certificate were to be exhibited as the work of art or as a reference to the work of art. My interest in the role that a certificate of authenticity played in the making of art grew. Although this project, Assigned Value, had all the similar aspects of my previous project, it now encompassed a significant element. Realizing that I was capitalizing off of the unacknowledged labor of migrant workers, I decided to not only credit the construction crew present during my photo documentation of the project as co-artists of my project, but to also compensate these same migrant workers should I sell the certificate of authenticity to this project. The certificate did sell for $10,000, and that amount was split in 4 ways. The other artists, as you can see, are Alejandro Sanchez, Miguel Espinoza, and Roberto Alcala. During my first year of law school, I had to take what are considered the 4 fundamental doctrines of law. Property law is one of them. The first day of class, my professor instructed us to begin with the second case in our casebook and skip the first case, Johnson v. McIntosh. I, of course, read it. That case from 1823 is the seminal property case in this country, where the U.S. Supreme Court established that Native Americans did not have title to their land, and thus that the settlers to this continent obtained title to the same land due to the alleged discovery of it. Similarly, in the 1950s, and through the legal process known as eminent domain, the city of Los Angeles evicted an entire Mexican-American community from a town that was once called Chavez Ravine, in order to build what is now the Los Angeles Dodgers baseball stadium. I have to laugh at the irony in this, because both my grandfather and my father, as most Mexicans and Mexican Americans living in LA, were and are diehard Dodger fans. The law school project continues. Since graduating law school, I have considered my law practice and all that it entails to be an extension of the Cornell Law School project. For example, in 2010, and with the intent to create a different and contemporary mode of understanding culture, I launched an artist residency that would focus on investigating the theoretical relationship between art and law. The program has been quite nomadic, having had more than 4 homes. It is run on a shoestring budget, but now has over 70 alumni and over 20 seminar leaders, which consist mostly of legal scholars and artists, critics, curators who in some way or form deal with law and the juridical apparatus. Some projects are more aligned with traditional artistic practices, such as this project from 2013, where I provided 12 pro bono legal consults to artists at the Hessel Museum at Bard College. The one-on-one consults took place in a room within the museum's library, in private, and were confidential. After my one-day 6-hour performance, my only presence within the gallery space was indexed by a stack of my business cards, as you can see in the circle to the right. Here's a detail shot. The museum was then invoiced at a lower rate for my legal services. My artistic practice also consists of a non-traditional artistic practice, such as where I legally represent artists. In other words, it is the practice of law as non-symbolic art practice, a practice of making law visible and not opaque, of making law accessible and pliable, of making art and law a medium. For example, what is the artistic effect of filing a lawsuit or of sending a cease and desist letter? For me, as an artist, it is another way to impact the history, criticism, interpretation, and making of art through the medium of law. A cease and desist letter or legal action can carry the force of law. They create a conflict, a legal outcome, and at times a legal opinion. This conflict, legal outcome, and legal opinion, which once only secondary information, now becomes primary information that an artist and an art historian can employ to create artworks and scholarship, which in turn impact the making, function, and interpretation of art, which then in turn impact the drafting of law review articles, legal and judicial arguments and decisions. And then we start all over again. In this document that you see here, it was what's called an amicus brief, friend of the court brief, where we were petitioning for a client, an artist named Chapman Kelly, to the US Supreme Court to hear his case. And this case dealt with whether or not natural and organic materials, such as plants, would be protected by copyright and what are called moral rights, a subset of copyright. And one of the problems that the attorneys I was working with were having was seeing that work as being a sculptural work. And so I brought in Rosalind Krause's Sculpture in the Expanded Field. And I managed to include it in this document. And so now, if you were to read it in the Supreme Court brief, there is a footnote with a lengthy paragraph of Rosalind Krause's Sculpture in the Expanded Field. But there is also a different type of materialization. This is a project that came out of the Masmoka versus Christophe Buchel litigation. It's a project, sculpture piece by Christophe Buchel, where he hired, I believe it was a 10-year-old boy, to read verbatim the court's opinion where Buchel lost here in the US. And inside there's an iPod with a recording, and the Mickey's face moves, and it sort of reiterates the judge's opinion. In postpartum document, Mary Kelly explains that the scribbles of a 2-year-old child will eventually turn into diagrammatic marks, crosses, circles, squares, and triangles, and that these marks will eventually become, on the one hand, the signifying system of a written language, and on the other, the signifying practice of art. To me, law as language, practice, and medium has become the signifying practice of art. Thank you.
I just wasn't clear exactly on the case and like where you consider your like place in it as an artist. Is it because there's no one there really to point out that there is performance, and that kind of in of itself is interesting? Like the dialogue has nothing to do with art if you weren't there, or like.
Yeah, like what's my role?
Yeah, like
what
where
am I
do you
actually
see
doing?
your, yeah,
Yeah.
I guess.
Well, that's what you're describing, like the Rosalind Krause to me is one simple way to intervene. But I'll tell you this much, when I stopped teaching at USC in 2003 before law school. I used to teach a lot of critical theory, the kind of stuff you guys are reading. And I had one student of mine come up to me and ask me, after class, he said, Sergio, you know, I love the stuff you're teaching us, but, you know, Derrida, Deleuze, all this stuff. And he says, but what am I supposed to do with it? What do we do with it, right? I had never actually thought about that, you know, so then it made me realize that, like, am I just parodying this, right? Or what is its actual rubber to concrete element? And so I think eventually what's going to happen is I am going to be disbarred, because the more and more talks that I give, I release more and more information of what I do. But one of the things is I forum shop, to use legal language, for certain plaintiffs that will bring either claims or potential claims against adverse parties, right? With the intent of shifting the way art is interpreted, number one. Two, the way law looks at what is art. And conversely, what impact can art and culture have in the formation of law, right? And a very specific case that's not mine is obviously the recent gay marriage decision, right? Where people can say, most people say, well, that's the Supreme Court deciding finally. But that mobilization happened from the 80s, you could say, right? When there was certainly the moment of the AIDS crisis. And if you didn't have something like films like Philadelphia, right, you may not have had that consciousness start to shift, number one. Two, when I was in law school, was when Justice O'Connor started to shift her perspective on gay marriage. And why was that? Because she had taken a clerk, which is someone who helps the justices with drafting and researching. She had hired this woman, not knowing that this woman was gay. And after, when she would invite them over for dinner and such, she started noticing that this woman was bringing another woman. She says, oh, well, how come you don't bring your husband? And it was pretty clear by then. And in that moment, it started to impact O'Connor's view on gay marriage. So it's with that type of intent that I approach my practice. And so I'm honestly more interested in art. I mean, that's my battle. It's not about law, really.
Because there was something at Mass Mocha that you probably know. I can't even think of the artist's name, but where he had work and Mass Mocha wanted property. So can you tell us about that? Because I don't know if.
Yeah, so this project started in 2006. It was by a Swiss artist named Christoph Buchel. He was at first asked to propose an installation at Mass Mocha. How many of you have been to Mass Mocha? Oh, okay, it's a huge museum, right? Terminal 5, I think, or Space 5. And so Buchel visited. He returned to Switzerland and drafted up drawings, maquettes, materials list, and all this is important, right? Because eventually it becomes an issue as to whether or not his work was infringed under US copyright law. And one of the ways to prove that is if in this case, the author, artist, has in some way materialized his or her ideas in a tangible medium of expression, which he did. Maquettes, drawings, sketches, materials list. So anyhow, he proposes the project called Training Ground for Democracy. And the museum loves it. Okay, but unbeknownst to Christoph, neither the museum director nor the curator had ever actually seen Christoph's work in person. And this is crucial because they thought this is an artist that comes in and just puts junk in a room, right? And it's quite the opposite. Christoph is a bit, I don't want to say neurotic, but if he says, I need a cup of coffee from Joe's that's medium-sized, quarter empty with milk, that's exactly what he wants. It's not a bottle of water or just a cup with water or a cup with liquid. So the museum accepted the proposal, and it was supposed to open in late 2006 all the way to the end of 2008, because for the next elections of 2008, right? This is the end of the Bush year, Training Ground for Democracy. What was supposed to happen was that the viewer was supposed to navigate through his installation and actually physically enact what it means to be what a democratic process entails. So that's part of, it included sitting in a theater like this size, watching films, lying prone and shooting a gun. There was a full-size house. Okay, so it was a major installation. And they began installing the project, but little by little, the installation went in a way that Christoph did not think it was supposed to go and not according to his plan. So every time he flew back, he noticed that the museum had installed the work in a way that was not to his specifications, right? So he said, look, unless you fly me back with my team and we fix it, I'm not showing the work, okay? And the museum said, well, if you don't want to finish it, we'll just show whatever's here, right? And so you had the first moment where there's a stalling process, and then, like I said, the first thing the museum does, because one of their board members is married to a partner of a major law firm named Skadden Arps, was they contacted lawyers. And they said, what are our legal rights, right? So this is what interests me, right? Because now the museum is saying our first step is not to negotiate with the artist, it's to go to a lawyer. And so the lawyers said, well, as lawyers do, they tried to figure out how the museum can exhibit the work without violating any of Christoph's rights, which they knew very well were going to be copyright, number one, and two, what are called moral rights. So the stalling, the negotiations fell through, nothing happened. The museum said, hey, you know what, we're going to show the work. But then the lawyers kind of backed down and said, okay, look, let's sue Christoph first. This is a very interesting maneuver in terms of litigation, because what you want to do is put what was once the plaintiff now on the defensive. So by suing him, the museum said, we want a judge to say that the exhibition, the materials, do not infringe Christoph's rights. Well, they were arguing, we spent thousands of dollars, tens or hundreds of thousands of dollars, and this becomes an issue. Two, the public has a right. It's a nonprofit organization. And hey, you did all this, you left us behind, you don't want to work with us, you're being difficult. And so it forced Christoph to hire lawyers and countersue, alleging copyright infringement and violation of what are called moral rights. I keep saying that because moral rights come from, some of you may know Tilted Art, 1980s. But the Visual Artists' Rights Act of 1990 in the US is the first moment that the US recognizes a form of protection for artists that really protects not the economic rights, which is copyright, but it protects the soul and the spirit of the artist. This comes from the French, obviously, right? But in France and Germany, where they're very strong, Latin America, Argentina, very strong moral rights, it protects not only visual art, it protects film, literature, music, and they have widespread moral rights where you can't even show the work if the artist or the heirs say, don't show the work, don't exhibit the work. The US has a very weak version of that, but it does protect two main things. One, the right of integrity and the right of attribution to an artist. The right of integrity means that if the work is ever modified, distorted, or destroyed without the artist's consent, the artist has a claim against whoever damaged the work. So that was going to be one claim. Second was attribution, that if the work is labeled as this is the work of Christoph Buchel without his authorization, it's a violation of his rights. Right? So it's pretty strong protection to an extent. So anyhow, long story short, they go to trial, and the first thing the judge asks, Judge Ponzer, the guy who Christoph mimics with the Mickey Mouse, is where's the contract? Right? Because this was an installation that ranged between $150,000 to $300,000 budget just for his installation. Right? So the judge is like, look, with this amount of money, public organization, where's the contract? And they were like, well, we sent one this way, but we never got it, or we didn't follow through. But you see then, if you think about Mary Kelly's project, you can start thinking about, well, then when did the contractual formation begin? It began with the offer when the museum says, are you interested in doing a project here? When Christoph says, yes, you have an acceptance. Those that are taking my class know, right? We have the taco. So you have the offer, acceptance, you have consideration, which means there's an exchange of duties and obligations. And then the terms, that's the hard thing. What did both parties agree to? And they never really checked what the budget was. The museum would not tell Christoph how much money there was for his project. In fact, I keep looking over here because I wish I had my moral rights PowerPoint. But in fact, the museum had asked Christoph and his gallery, Hauser and Wirth, for $100,000 because they said, look, we have to buy the house that you want. And for us to buy the house, it costs $100,000. Right? And so Christoph, of course, says, look, I'd love to give it to you, but that means I have to sell $200,000 worth of art, right? Because the gallery gets 50, I get 50%. And he's like, I don't think my gallery is going to go for it. The gallery, of course, said no. And he's like, we're not going to just give you $100,000. Well, during litigation and what's called discovery, when both parties can ask each other for information, it was revealed that the museum had in fact received the house as a donation from a board member from MESMOCA. And this is where it gets really sort of Asher-like, because what started to happen was that through those documents, we found out that the house had not only been donated, the house belonged, those of you that have been there, across the street from MESMOCA is a place called Porches. It's kind of a posh bed and breakfast. Well, that same board member with other investors, through eminent domain, removed the community that was there to construct Porches. And then that board member, the house, instead of just taking it and destroying it, donated it to the museum, got a write-off because it's an in-kind donation. And then the museum says to Hauser and Christoph, give us $100,000. So during deposition, when the director of the museum was asked, look, you got this as a donation, why did you want $100,000? And he says, well, it's kind of like we paid $100,000, so we should be compensated $100,000, right? So there was never really like a legitimate answer for that. But I tell you all this because this is kind of when you're asking me, well, what happens? And in the teasing out of this, Christoph, I can say this now, one of the reasons that Christoph wanted to work with me was because he knew I would understand his project, that the whole thing was an art project. And so including the litigation and the documentation, the court proceedings, the oral arguments, and he has it documented, and he's shown one version of it in Miami at the art fair. When the trial was still on, the court had sealed some documents, made them confidential. And what Christoph decided to do was to photocopy those confidential documents, frame them, and show them in his fair at the booth. At that time, it was Michel Macaron, I think. And but he turned the frames inward, so the objects were there for sale, but you couldn't see them. So again, technically, they weren't being displayed. You couldn't view them. Well, at that point, SCAD and the opposite lawyers were like, well, you know what, we're not going to push that. They were kind of, because the more that they were pushing Christoph, the more that Christoph sort of unraveled the ball of yarn. But one last thing I'll say is that the museum, it was interesting because this is the first time that a museum sues an artist for the right to show the artist's work without the artist's consent. Right. And why is that? One, they made 28 arguments. The first argument was, this is not art. Okay. If it is art, the museum argued, we, the museum, are the authors. So,
Interrupt by asking if there's a legal definition of art.
no. No. There are legal definitions. But the museum said it's not art, it's just property, it's just stuff, and we bought it. So as tangible property that we paid for. And that was a very good argument. They were saying, look, if we can get the judge to say, this is not art yet because it's not finished, it's just stuff, right? Then yes, the museum could say, we paid for it, it's ours, we can do whatever we want with it. The second argument was, if it is art, we are co-authors. So we are artists with the artist. And I mean, it was amazing the arguments that they made. Yeah?
Oh, talking about copyright, about the Mickey Mouse doll. Was there ever a problem for him to show that? I know that Disney are lethal in chasing you down if you use their copyright.
No.
No? Not at all? And why is that?
Why is that?
Yeah.
I was hoping you would ask that. Because there's a section of the Copyright Act, Section 106, that says that there is what's called the first sale doctrine. So if you buy a book, or you go to the store, to the Disney store, and you buy a stuffed animal for a friend, and you give it to me as a gift, I can turn around and sell it. There is no copyright violation. Right? It's called the first sale doctrine. That's exactly what's happening here. He can exhibit the work, as if it's his own object, which it is, right? He purchased the stuffed animal. There is no copyright issue with the transcript itself either, the judge, because under US law, federal works, which Supreme Court documents are in the public domain. So we're allowed to use federal works all that we want, as long as they were produced by the federal government. No, I mean, I was just talking about this yesterday with my class, that Mickey is going to go into the public domain in 2023 as a copyright. But there are 5 different types of intellectual property: copyright, trademarks, patents, trade secrets, and right of publicity. Okay? So what Disney does is they say, how can we protect our stuff with any and all of these 5? So what they've started to do, knowing that it's an impossibility to extend copyright protection another 20 years. They did it in '98. It's called the Sonny Bono Act. It used to be the life of the author plus 50 years protection of copyright. Now it's life of the author plus 70, right? But so they got that extension.
It's the same with music, I think.
Yes,
Right,
all kinds
yeah.
of, well, in the US media, yeah. But what they're starting to do now, and I lied because I was supposed to wear my Mickey shirt today so I could explain this, but what they're starting to argue, if you notice up here in the little sweater, right, the little patch, Disney's now arguing that Mickey, regardless of size, is also a trademark. And trademarks don't have an endpoint. They last in perpetuity. At trial, the judge said that the museum could exhibit the work without Christoph's consent, so long as they put a sign outside of the gallery space that said, "This is not the work of Christophe Bouchel." Okay. Now, what's interesting about that is that if you remember when I said that in the US, moral rights protect the right of attribution, which means that only the artist has the right to say when a work of art is authored by him or her. So the court, the judge in the first case said, look, you can show it, museum, you have to put the sign that says it's not the work of Christophe Bouchel. And they said the Visual Artists' Rights Act does not apply here because the work was unfinished, the installation was unfinished. So VERA, the moral rights law, they said, does not apply to unfinished works. We got that reversed and appeal. But there's a problem with the opinion, right? Because if the moral rights law does not apply, that means the right of attribution doesn't apply. So then why then say you have to put a sign that this is not the work of Christophe Bouchel, right? And we asked the judge for clarification, silence, right? And so that's why we appealed. And on appeal, there were 3 federal judges, really fantastic judges, and they reversed it. They said there seems to be copyright infringement and moral rights does apply to unfinished works, and it seems like the museum did violate the artist's rights. And then they settled.
If there weren't those sketches before where everyone knew what the finalized version was supposed to look like, couldn't it be argued that it was finished?
Sorry,
Anyway?
what?
Like if he hadn't already made those sketches that was like everyone knew what the final version was supposed to look like, couldn't it have been argued that there was a verbal contract that this is what it's supposed to look like when it's finished?
So you should go to law school because that's kind of was our thinking, right? Because if you read the Copyright Act, copyright attaches at the moment of fixation. So if some of you are taking notes right now, the moment that you write something in your notebook is protected by copyright, even if it's 1/10 or 3/10 of the class lecture. So that was our argument on appeal, was that the moment that Christophe put that on a table, that was protected by copyright. And then he added this to it, right, and so on. And the federal judges agreed, the 3 judges agreed. They said, yeah, that's protected by copyright, therefore, his work is also protected by VERA. Yeah. Let me just say something real quick about the Disney. I don't just show this gratuitously, but I always love that question because I can show the image. This is actually from the 50s, 1950s in the US. And an artist created this, I don't know what to call it, drawing or painting, right? Every undergrad class Am I right? There's always someone who paints Mickey and Minnie, or Minnie and Pluto, or a threesome, or a foursome. You know, it's like a rite of passage to conceptual art or something. And so what happened? And I love that question because it goes back to the history of art and copyright. Disney decided not to prosecute and sue the artists, right? Now, why is that? Those in my class know the answer now. You probably don't know it. Because what was just coming about in the 50s in the US? TV, right? And this is the time when people still read. Like I remember, you know, well, not the 50s, but even when I was growing up, Life magazine, Time magazine, right? Newspapers. This was still the way of receiving information. So Disney, in conversation with the lawyer, said, look, if you sue, this image is going to go worldwide. Right? So keep it hush hush, right? If someone wants to buy it, they have to mail in $20, and then they get a poster in the mail, 6 weeks, 4 to 6 weeks. And that's exactly what happened. Same thing with Warhol. Those of you that are wondering about Campbell's and Brillo, yeah, there was potential litigation, but free advertisement. Right, so they decided not to sue. Now, of course, post-internet, you probably would have a very different outcome, certainly to this type of content. Oh, yeah, sorry.
Yes, so I always wanted to ask this question, but I've never had the chance to talk with a lawyer before about it. So how we
I'm
copyright...
going to bill you for this, you know that.
So how we copyright our work?
Go to the copyright.gov website, and it'll tell you everything you need to know about copyrighting your work. It's just, I mean, your question is just like, what is art? Let me see if I can bring it into something that I was referencing. Well, let's make it interesting. So if you think about intellectual property, there are scholars who say that something like copyright is not even a property right? That it's a positive law, right? It's given to us by men, right? That right to protect intellectual creations. And so if you think of the history of the world in 3 phases, that's the easiest way to think of it: agricultural, industrial, and then knowledge-based. The first 2, agricultural and industrial, are what economists call rival economies. What that means is the property is limited. In other words, we're here at this moment, so you can't simultaneously have a car wash here or a football stadium, right? It's limited what we can do with this physical space. And that's true for agricultural, bananas, tomatoes, petroleum, and oil, and industrial. But it's not true for the knowledge-based, the third phase. This is what revolutionizes. This is where we are now, where it's about intellectual exchange. Knowledge-based are what economists call non-rival economies. They're limitless, right? I can take that image and email it to 50 people, and I am not depleted in any which way. I still have my image, right? And so it makes it difficult because how do you prove damages in intellectual property? Like you're asking with a Mickey, right? How is Disney harmed if in fact an artist is showing a painting of Mickey or a stuffed animal of Mickey? What is the damage, right? And the only damages, the major ones, one is what we'll argue are economic. That by doing this, Disney is not receiving, not this, but let's say wholesome images, Disney wouldn't be receiving royalties or payments for the use of their intellectual property, right? And what's great about knowledge-based property is that you don't have to own anything, right? In New York, if you want to be a landowner, good luck, or a billionaire. You're going to need to be one of those 2. But with the knowledge base, you don't need anything but a pencil and a piece of paper. And think of the person who drew Bart Simpson, Beavis and Butthead, Star Wars, right? All of those come from here. They're not tangible. They didn't exist. But because they're so fictional, they receive even more protection, intellectual property protection.
You mentioned, like, briefly in passing that you said you might be disbarred at some point. Why would that happen? And then what would happen to your practice when and if that does?
Well, the second question, I'm not going to tell you what I'm going to do, but no. Well, you know, lawyers are governed or restricted by certain ethical rules per state in the U.S. Right? So mine are New York-based. There's certain things like confidentiality. So if you were to become my client, whatever communication transpires between us becomes confidential. Right? But similarly, when you are dealing with an adverse party, there are certain rules that apply to lawyers when they are negotiating a dispute, and then certainly once a lawsuit has begun. Right. So, for example, there's federal rules of civil procedure of evidence. Rule 408 says that if you and I are negotiating a dispute, and I say to you, look, I'm going to make you an offer of settlement. Let's settle for $1 million, and you never tell the public A, B, and C, right? And you say, you reply, and you say, this negotiation is covered under Rule 408, right? Well, what would happen if that information was revealed, right? By, say, me, that information could be prejudicial, certainly to the adverse party, right? But that's where you do a cost-benefit analysis, and you say, well, at the end of the day, what's more valuable, the release of that information or keeping it confidential? Not that I would ever do that. I'm just saying that's one thing that could happen.
So you describe, or if you describe a shift in copyright laws and the way that we see them, or at least the justice system sees copyright, can you say where you think it's going, or is it, where are we going with it?
Yeah. You know, it used to be that copyright was really, those were disputes between corporations, right, fighting over intellectual property, patents, copyrights, trademarks. And then it turned into corporation versus the individual. And what I'm seeing a lot now is artist versus artist, right? And I think for me that's really interesting because, again, if you go back to Mary Kelly's work, where has that alternative form of dispute resolution gone? Why are artists increasingly looking to lawyers preemptively, setting up structures such as businesses, protecting their assets, but also, especially with appropriation art, the minute that there's a dispute, the first thing an artist will do is talk to a lawyer, right? And so why is that? You know, well, one thing we could speculate is that art making has become more of a business. It's an asset. And as artists, we have started to realize that everything we do is a business, right? Whether it's your Instagram feed, your Twitter feed, your resume, your website, your studio, you become a brand. And like any other corporation, you have to protect it. Right? Otherwise, why would you want to negotiate or talk to or consult with a lawyer, right? So artistically, that's where I see it. And it's not just between artists anymore, it's between institutions, where institutions are using intellectual property as a way not only to monetize and fund the institution, like say the Warhol Foundation. You know, these grants don't just come from anything, they come from licensing of Warhol images, right? But also they're using intellectual property as a way to control the scholarship that is being done on artists. So sometimes if you want access to certain historic artists, their archives, you'll be told you can access it, but no photocopying, right? No photographing, nothing. If you're even given access to it. And why is that? Well, because they may not like what you're going to say about that artist. And so those foundations or estates will first ask for you to propose what you're going to write as to whether or not they're going to give you access to their archive.
And the first one is related to your work, the one where you documented the property that was being built. So in those photographs, the binding contract wasn't a part of the, like, that wasn't an element in the artwork.
Oh, the
So-
certificate?
Yeah, the certificate. So why was that?
Oh, I'm glad you asked that question. So I have lots of people who would disagree with me on this. But if you think of the work of Saul LeWitt, Felix Gonzalez Torres, two key examples, the question becomes, what is actually the artwork? You know, with Saul LeWitt, there was an interesting dispute a few years ago with Rana Hoffman Gallery in Chicago. A collector who owned a Saul LeWitt drawing contacts Rana Hoffman and says, you know, I want to sell my Saul LeWitt drawing. And so she says, okay, do you have the certificate of authenticity? And he says, yes, here it is. So about 6 months later, the collector calls Rana Hoffman and says, hey, any sales? Did anyone buy the work? She says, well, guess what? This is where I kind of fictionalize a little bit. But I think there was an intern that was working there, and the intern didn't, you know, to the intern, this was just another sheet of paper. And so they lost the certificate, thinking that it was either shredded or filed or used as a wrapper for gum, something. But the certificate is gone. But Rana Hoffman says, don't worry about it, because I have art insurance. So that collector says, great. $600,000 is what it was valued at the time, I think. But it was supposed to go at auction at something like $3 million. So the insurance company is contacted, and the insurance company says, yes, you have art insurance. What's the artwork? And they describe the artwork, and they say, no, we don't. That's just a document. We insure the artwork. Now, try explaining Saul LeWitt to an insurance agent, right? I mean, and it really came down to the drawing on the wall, the instructions to the drawing, and the certificate. And the insurance company says, no, those two things. One are the instructions that tell the artist how to make the work. The other document just proves that that work is made by this artist. But those aren't the artwork. The artwork is the drawing on the wall. And, you know, they're not idiots. In a certain way, they're right? I mean, what is the role of the certificate? And with Felix Gonzalez Torres is very similar, where incrementally throughout his life, he fine-tuned his certificates, where the latter ones say the certificate of authenticity is the work of art. Now, when I first heard it, think about those of you that like Felix. I was devastated. I couldn't sleep that night. Because what do you do? I'm joking. What do you do with the fact that, I mean, what do I do now when I go pick up some candy? What is that? Or I pick up a poster and I roll it up and take it home. Or the light bulbs. If the certificate is the work of art, then why do I need the light bulbs? Why do I need the candy? Why do I need a stack of paper? But this actually starts with Manzoni, and pre-Manzoni with Duchamp. Duchamp was the first one to create a corporation of a corporation, right? And I think he foresaw that happening, the corporation, the artist functioning as a corporation and selling solely intellectual property. So now, to me, the issue is it's no longer about the armature, it's that sheet of paper, because that's the stock that tells you what you own. And the reason I call these aesthetic property rights is because, again, if you think about those three phases that I talked about, right, in agricultural, industrial, knowledge-based, I think there's a fourth phase that's being developed, and that's aesthetic property, where now we're going to have to pay for a feeling or an experience that we have. That's also going to become commodified. And there are already movements towards this. Like, one, if you think about these tourist attractions, you know, like go down the Amazon for $2,000. Right? And so you pay $2,000, you go down the Amazon, and what do? They point and they, oh, look at that monkey. Right? And, oh, look at that fish, the piranha, and you look at it, like, oh, here's your $2,000. Right? So what are you paying for? Right? And then, like I was saying yesterday, I think you remember that seminal trademark case in Texas over tacos, where two restaurants fought it out over the aesthetic experience of a restaurant.
But that would come under intellectual property,
Yes,
right?
trademark, or what's called trade dress.
The
now.
fourth point, that would be,
Oh, no, I think it's more based on, on feelings, on emotions, where
Emotions, okay.
that sensibility, I call it aesthetic for lack of a better word, is going to be something that is also going to become commodified.
and my second question is, Richard Prince keeps winning the cases, right?
No.
But he doesn't. But he does get away with it, and he
I hate when people
appropriates.
say that. Look, here's the thing. Many times artists, I showed the Brooke Shields. How many have you seen this image before? Okay. So here I'm showing it in full. Yesterday in class I didn't because I was in London when he had his retrospective at the Tate, and Interpol removed it because it's unclear whether this is child pornography or not. Okay, under federal law in the U.S., whether this falls under child pornography, and so I tend to only show the face. But the reason I bring this up is because the photographer who originally took this paid Brooke Shields' mom, got a release in perpetuity, which means forever. So the photographer owned the rights to this image. Okay, that's your intellectual property. Richard Prince wanted to rephotograph this, as we know, and he approached the photographer and asked for permission. So contrary to popular belief, he does ask people for permission. That's number one. The photographer, based on their agreement, which is confidential, cannot say or has not said whether the image was bought by Richard Prince or was licensed by Richard Prince. Okay, so that's one. Two, I can tell you this because of my client who's a photographer dealing with the Instagram fiasco. There are allegedly other photographers who have been who were contacted with the attempt to license the works for the Instagram works. Okay, but it is a myth that no permission is ever asked, because I can tell you that his lawyers, who are in the $600-800 range an hour, are telling him, look, this is a business you're running. Why don't you pay $1,000, get it licensed for life, right? It's only $1,000. Or you face a lawsuit, attorney's fees, plus if you lose, which you probably will on the Instagram works, right? You're talking potentially millions of dollars. Yeah? But I think when you're probably thinking about this case, it was probably the worst decision for artists that has come out in the last 10 years, the Carey UV prints. And the reason for that is the Second Circuit here, the Court of Appeals in the Second Circuit in New York, said that 25 out of 30 of Richard Prince's paintings are fair use because they transform Patrick Carey's original photographs. But what they said, it's kind of convoluted, is that to do a visual analysis, you have to put both images side by side, the original copyrighted one with the appropriated one, and then based on a reasonable observer, that's what the court said, the reasonable observer must then analyze and assess whether the second image has been transformed. Now, I'll give a Snickers bar to anyone who figures out why that's a problem for appropriation art. I'm typing Snickers. Mm-hmm. It's very subjective, right? Who's the reasonable observer? Well, Richard Prince's side was arguing it's museum curators, it's art critics, art historians. Those are not reasonable observers, not to me, right? But on the other hand, is it the hot dog vendor? Right, so there you have one problem. The other problem, of course, is going to be this one. If you put these works side by side now, seminal cases from the late 70s, early 80s, and you ask a reasonable observer Keyword is reasonable. Imagine there's two of them, side by side. What has been transformed into the second one? Nothing. So ironically, the court, it almost put copyright law back for artists 40 years.
It didn't recognize context as transformative.
Well, Prince's side was arguing context, right? But the judges don't want to go there yet, because what they in fact would be doing is saying art gets special treatment. But why art, right? I mean, if you think about change of context, if I take a Mickey and put it on my T-shirt or on my backpack or on my strip bar, isn't that a change of context? Right, so it can't be just change of context. It has to be sort of like art context. But then we have to argue why art gets special treatment. So when Levine had her exhibition up at the Whitney, there were works that she was told if she showed, she would get sued. And there are other works where she agreed to put based on the work or after so and so on, right? And then copyright the estate. So again, you have artists now, and based to your question earlier, where they're now having to negotiate and settle preemptively to exhibit artwork.
My second question was related exactly to context.
So
My second question was again related to context.
context.
So when a work does get transformed, like when it's recognized by the courts as a work that is transformative of the original, it's obviously based on the original. So that is a process that's developing now. And like, is the court like I don't know, including all of this in any of its criteria? Or I mean, it's happening.
Wait, is the court what?
I mean, is it taken into account, all this information, the fact that like art is operating as something that's based on maybe...
This is why it goes to the first question over here. This is what interests me, right? Because if you leave it up to, no offense to just lawyers, but to lawyers, they'll fuck it up. I mean, copyright law really is a clusterfuck right now. If you remember in my class, I said how in the US there are what are called circuits, right? So different federal courts, First Circuit, Second Circuit. And the Wild West one that's just way out on the left is the Ninth Circuit in California, clearly. But the smartest ones are the Seventh Circuit in Illinois, and arguably the Second Circuit in New York and the Fifth Circuit that covers Texas. Conservative in Texas, of course, very economic based in Illinois, and then more liberal in New York. But they all have different ways of assessing copyright disputes, right? I spend time in this because this is very interesting. When you look at Seventh Circuit opinions, they look at the economic ramifications of appropriation. Seventh Circuit, the Fifth Circuit in Texas, very pro-property, very pro-copyright. Second Circuit, very pro-artist. But what's starting to happen is, even in New York, is the court starting to move more towards the right, recognizing that, wait a minute, right? There is appropriation, but I think the next step is recognizing artistic intent, that the appropriating artist has to have a reason why he or she is taking copyrighted work.
You were describing how it's people are like artists are it's transitioning towards like from corporations to artists suing each other. Do you not think that we live in like very like intimidating times of like everybody's suing everybody? You have to be very aware, very conscious, versus what it used to be that it was not so developed up until, I don't know, the middle of previous century, and people just, like the human spirit was the most important thing, and like intellectual property was for the benefit of everybody, for the benefit of human beings, and like stuff like that. And like it's now getting to a very detailed contracts and to a very detailed law that says exactly and very punctuous to the level that it's almost like limiting so much. Like from instead of like just using common shared knowledge and like what the human spirit can bring to everybody. Like, can you comment on that?
Yeah, I mean, it's something I think about a lot. I mean, this what you're asking really is the question of property, right? Of what is property, and if you think about it, it's not a tangible thing. It's the relationship between me and this thing to you. Okay, so what that means is, it's not the bottle of water. It's how many ways can I fragment my ownership of this bottle of water. So I could sell you a drink, one sip, for $1, right? And then sell 5 more, and I just made $6, right? Based on the ownership. But it's not considering the physical thing. I could sell the whole bottle. I could sell you just the plastic without the liquid. I could sell you just the liquid, right? I could let you hold it. I could let you look at it. Right there you have about 6 or 7 what are called sticks of rights that I have to this property, to this thing, right?
You can sell me the concept of
Yes, I could sell you the certificate of authenticity to the bottle of water, right? Exactly, now you're getting it. So the smart people are like, how else can I extract a right from the same thing? Mm-hmm. And the reason this is, I like your question, is because you should, if you're interested in this, there's a seminal essay from the 1950s called The Tragedy of the Commons. And it's predicated on the concept that, why is it, goes to your question, why is it that, as David Mamet says, the reason we have the US Constitution, I'm curious what your dad thinks about this. The reason we have the US Constitution is because human beings are fundamentally evil. Okay? And so you need a regulating system, something that tells you what rights you have. But the tragedy of the commons kind of starts there, and it says, okay, if we have this plot of land and all of us have a cow and we each have a little square, why is it that eventually one of us will say, hey, I'm going to put 2 cows, and then someone else does it, right? But what does that start to do? It starts to erode the ground. You have less grass, more water, and then someone else says, I'll put 3, I'll put 4. I'm going to stretch onto your property. And thus we have Johnson v. McIntosh, right? The conquest of property. And what you're asking really is, where does that impetus to want to commodify come from? If you think about conceptual art, I remember at the ISP, the first person that gives a talk is Vito Acconci, right? So he's like this, like smoking, and he's like rocking back and forth. And he says, what we wanted to do in the 60s was get rid of the art object. And instead what we did was create the fucking 80s, right? And it's true. What did he, it was like, if a piece of paper with text on it is art, then anything can be art. Right? You have Sandro Kia, right? That's what you get. Thanks for laughing. Does that, I mean, because it's a very complicated answer. It's not a cynical, it's a pessimistic viewpoint. I mean, Buchlo just came out with this book on criticism, and I think goes to this, what you're saying. And to me, the reason his writings are interesting is because artists, like I was saying earlier, rather than negating or countering a corporate model, a for-profit corporate model, they've absorbed it. They want to participate and be like a corporation.
Yeah, I just wanted to add something that, so my comment came from, I watched a few years ago the movie that Girl Talks, that a musician that appropriates segments of music and make his own music. So I saw he made a movie about copyrights and how it's getting really fucked up lately, and how it's, so he in his view, it's like a revolution, and like you're supposed to, it's supposed to be that you're breaking the law. It's supposed to be that you're doing that, because those who are trying to surround themselves in the tower of capitalism with all of these contracts, they're just going to surround themselves with more and more contracts, where the actual ground of sharing and all of that culture is going to spread out and take more and more.
But that's a very romantic view, because that's what the Buchlo it says that's a belief in the avant-garde, right? And to go back to your question with Prince, what's the first thing? Look at any Richard Prince catalog on his work. Open the first page or the last one where the credits are. And what are you going to see? You're going to see a C with a circle. That means copyright. The year, Richard Prince, right? So if someone's arguing this stuff should just be up for grabs, why then propertize this? Why then say everything's up for grabs but my book, right? Kenny Goldsmith, right? He's a big proponent of free culture. Open up the second page to his book, look at the credits, and what are you going to see? The C with a circle. You don't need a microphone. Now we're going to end on a cynical note.
Well, yeah, I'm going to suggest that maybe your answer to this might be the last question. But first, in answer to what you just said, I think part of it is that the publishers will usually require it.
Mm-hmm.
You know, Kenny Goldsmith might be an exception potentially, but it's hard to publish a book without asserting copyright.
You could self-publish.
You can self-publish, yeah. Okay, so what I wanted to ask was not so much about, you know, the legal matters that you have talked about, but just more personally about your path as an artist and as a lawyer. So, you know, our students, especially those in their second year, are contemplating what they're going to do next year and the year after and the year after that. I think most of us hope to be, you know, long-distance runners, you know, as artists, not sprinters, you know. I hope most of you aren't thinking, okay, well, I'm going to give it a go for a couple years, and if I don't become the next Jeff Koons, I'm going to throw in the towel and go to business school. I mean, we're hoping to do this, right, for the rest of our lives, and to find a way to do it sustainably, and you're finding a way. And it's a very innovative path, right? There wasn't actually, I don't think there's probably a single model out there for you as someone who went to law school as an art project and is now practicing law as a ongoing blurring of art and life performance. Just a couple weeks ago, we had J. Morgan Pewitt, who does Mildred's Lane, as her kind of blurring of art and life. So you're another example of that in a way. You know, when people ask, well, so, you know, what should I do to make a living? And, you know, you can go out and look for a day job where you can do something more inventive. And in trying to figure out what that thing ought to be, I often say, well, look at what you're really passionate about, what you really love to do, and look at what you're good at, and the overlap of those two things is where you should put your energy. And I'm just sort of wondering for you, how's it working out? How you feel about this path that you've crafted for yourself? Was there a moment that when you were, say, at Cal Arts, when it all crystallized and you thought, I'm gonna go to law school as an art project. I love arguing and I'm good at, reading text carefully and.
I actually hate to read and write. Just ironic because now I make my living that way. Someone thinks I'm being bitter, but I'm being honest. I gotta read. I gotta read Mary Kelly's work now. It's like, ugh. No, I'm kidding. I like reading, but I like that question too because, in this type of forum, because it allows me to see that. It's really about self-sufficiency. I realized a long time ago that I wasn't making the kind of work that I was supposed to make. Like I remember in certain studio critiques, people were like, well, why don't you talk more about where you're from? I was like, I am. And they're like, no, but where you're really from. Or, my sexual orientation, whatever, right? And then I got it, I was like, well, I don't do that. I'm interested in ideas. Because I was doing all the wrong stuff. And I thought, okay, so the gallery thing isn't gonna work. Teaching isn't gonna work. So I started to realize that also, as we know, there's no federal state funding for artists.
Can you quickly explain why gallery wasn't gonna work and teaching wasn't gonna work? Why did you conclude that those weren't viable for you?
At the ISP, I had quite a few studio visits with gallerists. And this is when I was theory crazed, addicted. And so you already know where this is going, right? And so, the gallery dealer would come in and say, so show me your work. And we'd sit there for an hour and I'm going into Deleuze and Lacan and Benjamin and, Kant and Hegel. And the poor guy's ready to shoot himself. And after the whole hour, he just says to me, so, but can you go back to slide number 98 and tell me why you use red and blue? And then I was like, that's when it hit. I'm like, we don't communicate. These people are not for me. This is not my venue. And it's not dissing it, you know, it's just like music, right? If you realize you're gonna play heavy metal, you're just not gonna play at a country bar. You just realize that. And that was my first experience with galleries, and I thought, okay, if I wanna do what I wanna do, it's not gonna be in that venue. I didn't know
So academia should be perfect for you then, right?
Well, then I thought academia, but then the problem with academia was that it's too academic, right? That it's too, and politically, let's be honest, to the left. And so one of the things that I loved about law school was that I sat in the middle of the president of the Federalist Society, which is like Ted Cruz, and then, you know, on the other side was like the president of the legal guild, law guild, which is like, you know, Bill Clinton. And so they're like going at it, but they're not looking at each other. They're looking to the front, addressing the argument. And I'm like visualizing it, and I'm thinking, wow, this is like really fascinating. This is the formation of the art and law program. I was like, why couldn't we have those discussions at Cal Arts or the ISP or at USC where I was teaching, you know, at Irvine? Because the conversation was already so heavily weighed in one way that God forbid you raise the other argument. So then I thought, okay, academia is not gonna work. And also, you know, I'm not gonna say which school I was at where I was teaching, and I saw a tenured professor, and I was like, I don't want to be that guy. No, I don't mean that like in a bad way, but
That's it, I'm leaving.
no, not, you know what I mean? I saw it and I was like, yeah, you know, and so then I thought, okay, so I stopped making art for a year, and then you know, I thought enough Deleuze and Derrida, like what is law? And Gayatri Spivak, who some of you might know, a post-colonial critic, I spoke to her over the phone from LA, and I said, you know, Professor Spivak, I want to study with you at Columbia and get a comp lit degree in studying art and law. And she said, no. He said, if you've ever like dealt with Spivak, she's like terrifying, right? And she says, no, because you are interested in power and language and structures. And if you were studying the military, what would you do? And I was like, get a PhD in military history. She's like, no, you have to go to boot camp. And I was like, well, what's boot camp for law? Jail. Yeah, jail. Yeah, that's your project.
I've already said jail.
And anyway, long story short, and then began but then I fell in love because this is sort of like, internet wasn't like, websites were so radical that not everyone had a website. So I asked all these law schools for catalogs. And I started flipping through the course catalogs, and it was like Nietzsche and law, you know, Heideggerian interpretation of Constitution. And I was like, holy shit. You know, there I go back into the rabbit hole, right? And that's what happened.
And so how's it working out?
Good. Like I said, I'm very lucky to pick clients that have legitimate. Like I'm starting to advise a group of artists that have a very legitimate beef right now with a big institution, and so I get to pick pro bono or fees. I charge those that have money, and I charge less to those that don't have money. And yeah, then I get to do this, and I write, teach.
Okay, one last, follow-up question, and then we can wrap. Do you still feel like an artist in what you do?
Yes, more so, because, when I always, okay, so my second answer to yours is this one, right, which is, I know people are gonna laugh, but I really say, like, if you look at Bruce Lee, to me, that's my model, okay? And I know you're gonna be like, that Joker. No, seriously, like, if you look at someone like Bruce Lee, he started off, he was like a little thug. And so his parents put him to study martial arts, Wing Chun, which is a form of martial arts in China that was developed for women. And it was like very, close proximity fighting. And so then he would learn all these moves, and he'd go out and pick fights, and he'd get beat up. And he was like, what? He goes back to his masters, and he's like, look, you're teaching me all this stuff, and I go out and get my ass kicked. They're teaching him more moves, he goes out, gets his ass kicked again. And then he starts like looking around, he starts noticing the way people fight. And he's like, they're not fighting like this. So what does he do? He studies every single martial art, sabate, kung fu, karate, taekwondo, wrestling, Greco-Roman wrestling, everything, even the ones he didn't like, because he knew that eventually he would face someone that would come at him with a move that he had already seen, even though he didn't employ it. And he created, out of the 26 martial arts, his own. But he never said it was a martial art. He said it's a philosophy. And it's Jeet Kune Do, right? The way of the fist. But it was a way of life. And he said, look, I learned by watching animals fight and by watching actual people fight. And it reminds me a lot of like when you learned how to draw and your teacher says, draw your hand. And what's the first thing people do? They go like this, right? Your 5 fingers. And then you learn that what you're actually drawing is what you see, right? What are you actually seeing? And for him, it was the very same thing. It was like, he looked at dogs, you know, tigers. How are these animals fighting? And this is how he developed his own way of being. And so, you know, to me, that's my model. It's to take all these things and why not develop, like, you know, I think about like Center for Land Use Interpretation, CLUI. To me, they're artists. Like, that's an artist. They can be in the Whitney Biennial, and then they go back to doing their thing, right? They don't get like carried away. I think there are other, you know, people doing similar things where it doesn't have to be locked into. And that's the thing for artists, right, is that we constantly think that for me to be an artist, I have to do this. But the hard part is, how can I do something where people are gonna laugh, right? Or ask, are you still an artist? Right? It's like, but you know, also if you look at models like Zuckerberg, like why are the interesting creative people not in art anymore? Right? The people who are doing interesting stuff don't call themselves artists.